Thank you for coming, Lieutenant Governor and Council. I stepped out for a few minutes to go to another hearing, so perhaps some of what I'm going to ask you about has already been covered. But I don't think so, because my concern, Representative Tong, or Chairman Tong, indicated that there are essentially two sides of the story. One is that this bill would protect victims of domestic violence, and the other side is that it burdens lawful gun owners. My concern is that there's not just those two sides. My concern is that this bill, as it's written, makes things more dangerous for victims of domestic violence. My concern is that because there is no hearing, there is no way to tell who the victim is and who the perpetrator is. And it seems to me that without a hearing, an abuser could very easily go and get a temporary restraining order with no hearing against the victim, disarming the victim from having a defensive firearm to protect herself from the abuser. So I'm concerned that there are a lot of unintended consequences and situations that have not been considered in drafting this bill, that being the main one, that this makes it more dangerous for victims of domestic violence, not less. Now, certainly everybody in this room takes very, very seriously the dangers of domestic violence and wants to do everything possible to ensure that our laws protect domestic violence victims and do everything they can to ensure that they have whatever protections they need. My concern is that this bill makes things worse, and because it does not seem to account for a number of scenarios that I'd like to go through with you, it is not, you know, it makes things more dangerous for them. And I saw you reaching for the microphone, yeah, Lieutenant Governor, so please, if you have a comment on what I've said so far, I'd love to hear it.
Representative, the one thing that I can tell you about is that it's going on in 20 states now, that this legislation is already enacted. And what we do know is that we have seen 12 to 13% reduction of family violence in those states. So it's becoming a better way than in that short period of time, and that's what we're already seeing going down because this bill was introduced there and passed.
Okay. During that same period, what was the reduction in family violence in our state?
You know what? We're just guiding by the law that was there. That was
no, I
implemented.
understand, but you're saying that family violence was reduced in a number of other states, and I'm asking you if you know if that's a trend overall, and if our state had a similar reduction without this law.
I think is guided within that law. You know, we have examples of what's happened in our state just recently, as I testified on before. You know, the way that they've been looking at the other states, we've seen this reduction. They've seen a reduction in their own states from their own policy with the change of the policy.
Okay, but so, is it fair to say that you don't know if it was caused by that law and that our state may have experienced a similar reduction without that law?
I'm just reading what they have given, what each of the other states like Texas and Massachusetts and all those other states have given and said that there's been a big reduction after the problem was filed with the courts.
Okay.
And I think Representative Dubitsky and to the Lieutenant...
I'm sorry, I can't hear you.
Could you sorry.
Thank you.
And to the Lieutenant Governor's point, there are a number of initiatives that are going on in Connecticut backed by this administration and championed by the Lieutenant Governor and the Governor that have resulted in better response to domestic violence. But in a situation where somebody is applying for an ex parte restraining order or a full restraining order, that violence has already occurred. Or otherwise, the person who is applying for that restraining order is alleging that the violence has already occurred and that they are in fear that it will continue.
No, I understand the purpose, but you're citing statistics that there's been a reduction, and implicitly saying that the reduction in those other states was caused by the implementation of this law, and my understanding is that you really don't know if that's the case. Is that correct?
That it was reported by those states to have that reduction because of the law. That's, we're just using the statistics they gave.
Okay, but we don't know if Connecticut has had a similar reduction without the law, or other states have had a similar reduction overall without the law.
No, sir.
Okay. So, I apologize. I'm going to sort of bounce back and forth between different things because I was taking notes as you were talking, and I'll just go through them. You had indicated that if a law enforcement officer is the recipient of a temporary restraining order, they would have to turn over their firearms as well. Is that correct?
That's correct.
And how about if they're in the military?
I would imagine they'd have to turn it over also, sir.
Okay.
Everybody is treated equally in this.
Okay. So, and now, you said that the trigger is the ownership of the firearm, correct? Simply because they own a firearm, if the TRO issues, then they must surrender all firearms that they own. Is that right?
Only if the judge says they have to.
Okay. So they would have to surrender all firearms that they own. What if they're not in possession of firearms that they own? If they have a firearm that's, say, in a bank vault, they have a firearm that's being used by one of his hunting buddies, they have a firearm that's out of state, how do you account for the ownership of firearms that are not in the person's physical possession in this law?
Again, Representative Dubitsky, in terms of the issuance of a restraining order and the individual's inability to possess a weapon, it is no different under current law than it is under the proposed change to the ex parte temporary restraining order, other than the time period in which that weapon must be turned over. If you have a restraining order against you, you are not permitted to possess a firearm, and your permit is revoked.
Right, but you are, under this law, the moment somebody is served with this temporary restraining order, they are no longer legally allowed to be in possession of any of the firearms they own, right?
That is correct.
Okay, so how logically and how logistically would it work if somebody is handed a temporary restraining order? They have firearms, some of which are out of state, some of which are held by others, some of which may be in a gun store being sold, some of which may be in their house, one of which may be on her person. How technically would that work, that they are no longer able to be in possession of a firearm? They must, within 24 hours, surrender them, and simply by having one on their person, they are now in violation of a temporary restraining order. And I think you said that they are, I don't remember the words you used, but essentially they would be in possession of an illegal firearm at that moment, right?
Correct, and the same would be true currently under a restraining order, a full restraining order that is issued.
Right, but
under those circumstances.
But under a full restraining order, they would have a hearing, and they would show up at court without carrying a firearm, and they would have at least 24 hours to plan. Right now, they have nothing. If somebody is served, let's say they're served on the other side of the state when they're carrying a firearm legally. They're served with a temporary restraining order. They're nowhere near their house. It's a holiday weekend. There's no federal firearms dealers open. How do they logistically avoid being in violation of the temporary restraining order and possessing an illegal firearm?
Again, right, you have 24 hours to transfer the weapon, and under those circumstances, the person should immediately contact the police department in order to transfer that weapon if they are in possession of it at the point when they're served, because they are no longer, regardless of whether or not it is an ex parte temporary restraining order or whether or not it is a full restraining order, they are not permitted to possess that firearm.
Or their license.
Pardon?
Or their license.
That's correct.
Okay, so if they no longer have their license, if their license is no, if they no longer have a license to possess firearms, are they allowed to own them?
They have to turn it over.
What does that mean? You made a distinction earlier between ownership and possession. So if they no longer have a license to possess a firearm, they no longer have a license to own them, is that right?
That's correct.
Okay, now, but earlier you said that when the police or the firearms dealer takes custody of their firearms, they still own them and they're only holding them temporarily. But if they no longer have a right to own them, then they don't own them. So, you know, how does that work?
Again, it's, and I think I stated this earlier, Representative Dubitsky, the transfer of the possession of the weapon does not transfer its ownership. Should you not be able to reobtain a permit for some reason, whether it's this or any other thing that would prohibit you from having a firearms license, you would not be able to be in possession of that weapon. Presumably, you would then dispose of it if you're never able to use it, but that would be up to the individual. But with regard, there are a number of crimes, in addition to a restraining order, which would prohibit you from having possession of a firearm.
I'm asking about ownership.
I'm not quite sure what the distinction is that you are making. Again, the circumstances are no different with regard to that issue.
Well, no, but I'm asking you about ownership. You had indicated earlier that when you surrender a firearm, you still have ownership of that firearm, but you no longer have possession. But if you're also surrendering your license, you are no longer, in many instances, legally entitled to own the firearm. So are you surrendering ownership or just possession?
Again, this is a circumstance and where the restraining order is temporary. It is not. It's for a period of time, and for that period of time, you are not permitted to possess the firearm.
I'm asking about ownership.
Correct. There is no confiscation involved. It's transfer.
So it's a transfer of ownership.
Possession.
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 Okay, so the recipient of the TRO would still own the firearm.
Till the
Yes, that's what I've answered
Even
previously.
without a license.
the license is also taken away for a short period, the period of time till the final judgment is coming down. At that time is when you lose your license and you can no longer own a gun.
Okay, so, and perhaps I wasn't in the room when you said this, when you answered this, but, so if at the actual permanent restraining order hearing, the allegations are found to have been unjustified, will you immediately get your license and firearms back?
Again, you'd have to reapply, as I have answered, to the Board of Firearms
Okay.
Permit Examiners.
And
once your permit is restored, then you would be able to obtain possession of that firearm.
Okay, so even if the allegations are found to have been unjustified, you would still have to go through that process, which could take 2 years.
Again, that was the time frame cited. I understand there is a backlog. I don't know the exact length of the backlog, but that Representative Sampson cited 2 years. There is a backlog. I don't know.
Okay, so even under, so let's assume that that backlog is correct. Under this legislation, there would be no opportunity for a hearing. Somebody, before the firearms are seized, and they might not be returned for perhaps 2 years. And you may not even have, you may not even, not only the firearms, but you may not even have your license returned to you for up to 2 years, so you couldn't purchase another firearm during that period. Is that right?
You know, Representative Dubitsky, as you know, not every law, every bill is perfect in the beginning. If you think that you wanted to change, and the committee changes it regarding the period of time, if they are found not to be, the respondent is not, is found not guilty, you all can fix the legislation,
Okay.
but then,
And
then you'd have to vote for it too.
Would you support such amendment?
You know what? You know what? I gave up that license to be able to support an amendment when I left being state representative. So that's a decision that all of you make.
But you do understand the
I
problem.
do understand what you're saying. I do.
Okay, and you understand that doing that without any hearing would be an extreme violation of somebody's due process rights.
I disagree. I think the due process is in the bill right now. When you're talking about if they're found, I don't know if because I'm not a lawyer, but if they're found not guilty after that due process, the second part of the due process, then you can change, the law, and I understand where you're coming from. But during the time when there is an alleged fear or fear from these other people, from the respondent, I still feel that the pistol should be taken away, or gun.
Even though there's no due process?
There is a due process, sir.
Not before the firearms are taken, though?
It is due process because you're still going in front. A parte is the same part, and it's always been, that is due process.
Okay, but due process is an opportunity to be heard. And before your rights are taken away from you, you have no opportunity to be heard. Now, 14 days later, you may have an opportunity to be heard, but you just told me that even if after that opportunity to be heard, you're found not to have done anything wrong, your rights have still been stripped from you, not only for that 14-day period, but also for an additional, perhaps, 2 years. Do you believe that's due process?
I believe the due process is there for the 14 days, absolutely. And the due process is there. It's just like taking away, you can't go to your home because your wife might be there. That's part of the due process that is taken under the parte. What is it called?
Ex parte.
Ex parte. I knew I could never get that right.
Okay. Now, you mentioned that the judge looks at all the evidence before issuing a temporary restraining order, and that it's issued in the judge's discretion as to whether or not to issue it based on the evidence. The evidence is generally only one side, right?
An ex parte restraining order is issued based on the victim or the applicant is required to submit a sworn application.
Okay, and you had indicated that in the event that an applicant, I think your words were, anyone found to have lied on their application would be liable for making a false statement.
Mm-hmm.
Is that right?
That's correct.
Do you know if anybody, or do you know how many people have ever been found liable for making a false statement on a TRO application?
I do not, sir.
Would you be able to get us that information?
I certainly can check with the judicial to see if they have records of that. That's correct.
Okay. Do you know of anybody who's ever been found liable in that situation?
I believe I answered that question that I did not.
Okay. So, under this situation, a abuser could go in, file a TRO application, and have the abuser, the victim's protective firearm stripped from her, and if, as I understand it, there's very little chance of that person, of the abuser, ever being held accountable for making a false statement on that application, there really isn't any consequence to the abuser for having his abused victim stripped of her protective firearm for a period of up to 2 years. So that would seriously concern me.
I think you're making an assumption that nothing happens, Representative Dubitsky, and if you have statistics that indicate that nothing happens, then I would be happy to hear that. But you made an assumption that somebody can lie on an affidavit and have the judge grant that based on a false affidavit and nothing happened, and I'm not aware of that.
Okay. Well, I would love to see what the statistics that you bring back to the committee say as to how many people have been held accountable for false statements in that situation. And again, I guess I need to kind of go back to the scenario that I mentioned before. Somebody is away from their house, traveling. They're carrying a firearm legally, and they're served away from their home with this TRO. Are you, under this, are they then supposed to sort of get on the phone immediately, call whatever local police is there and say, come and get my firearm? I'm sitting in the Walmart parking lot with a gun, come and get it?
They have 24 hours, but they have to get rid of it by then.
But they can't be in possession of it during that time.
That would be correct. So
So-
they would have to make whatever arrangements are necessary so that they are complying with the law.
Okay, but under my scenario, what could they possibly do?
Your comments were perfect. You can call a trooper or the police and come pick it up at wherever they're located.
You don't see a potential problem with that, huh? I'm sitting here in Walmart parking lot with a gun, come and get it?
Again,
No.
the problem is where,
I'm sorry?
I'm sorry, I stopped because I was having trouble concentrating. Again, the circumstances would be the same regardless of whether or not it's a full restraining order or whether or not it is an ex parte restraining order. At the time that the person is served notice that the restraining order has been granted, they are no longer able to possess that firearm legally. So they need to make whatever arrangements are necessary and take whatever steps are necessary so that they are in compliance with the law.
Okay.
Attorney Buffkin, we've been informed that people are having trouble hearing you, and particularly CTN is complaining that you and Lieutenant Governor Wyman are not coming through. Could you activate the microphone to your left, and maybe that would help?
It wasn't working earlier, Senator, but I will try. It keeps ringing. It's not. So we'll
We'll
shift.
We'll shift over there, okay? There we go.
We're shifting right.
Oops. Whoops. Oh, my God.
But from your viewpoint, we shifted left. I'm sorry. I'm not.
So, no, my apologies for the interruption. You may continue.
Thank you, Mr. Chairman. Now, with regard to firearms in the house, let's assume the standard scenario where it's a woman who is the victim, files a TRO against a man who is in the house. The man is served at the house. The man has firearms at the house. He's no longer able to possess them. Within 24 hours, he has to do something with them. He can't find a licensed federal firearms dealer, so he calls the local police. So the local police are now able to come into his house to get the firearms.
Sounds under that scenario he's invited them to.
Okay, what if he doesn't invite them?
Then he would be in violation of the law.
Okay, would the police then
If he
be
has
able to...
not transferred them within 24 hours as required by the statute.
Okay, would the police then be able to go and get them?
There is nothing in this law which enables seizure of a firearm under any other circumstances than would already be permitted under the law, and the individual who fails to effect that transfer within 24 hours would be the individual who is in violation of the law.
Okay, and then what happens? If the person has a license for a firearm and has a registered firearm and does not transfer it within 24 hours, what happens?
At the point that they have been issued the restraining order, they know their permit is revoked, so they no longer have the ability to possess that firearm, and the law requires them to make arrangements within 24 hours to transfer it to a licensed firearm dealer or to the state police and the local police acting in their stead. So that is an obligation on the individual in order to comply with the law.
I understand that, but what if they don't?
He broke the law.
Then they would be subject to whatever penalties there are for violations of a restraining order
Okay, so if
and for possessing an unlicensed firearm.
okay, so if a person is handed a temporary restraining order by a marshal and does nothing whatsoever, just sits in their house, does nothing, doesn't call anybody, doesn't transfer anything, just does nothing, what's the next step?
There'll be a public, then they go to their hearing, their regular hearing, and at that time, the person that has been abused can mention that, he or she had a gun in their possession.
Correct. And they put themselves at risk for further
Okay, so
criminal prosecution.
so there's no follow-up, you're saying?
No, I'm not saying that. I'm saying the person, you're asking what happens then. The individual puts themselves at risk for further law enforcement action based on a violation of the restraining order.
And I understand that, but the goal of this legislation is to close this 14-day window where a abuser has access to firearms before a hearing. That was what the governor indicated was the purpose of the legislation.
That is
right?
correct.
Okay, so if the abuser is handed a temporary restraining order and does nothing, and does nothing until the hearing 14 days later, we haven't closed the window. So my assumption, and I hope you would inform me, is that if after that 24 hours the firearm is not transferred, that I assume there's going to be some type of follow-up, some type of knock on the door, issuance of a warrant of some sort. Is that right?
Yes, and I would presume it is the same process that if the person who, under current law, fails to transfer that firearm within 2 business days following notice of the restraining order, doesn't comply. The process does not change. We are simply, as you indicated, closing that 14-day window when people who are subject to domestic violence and abuse are at the greatest risk.
Right, but it does change because you eliminate the hearing, and the hearing in the other scenario you mentioned, the hearing would take place before the issuance of the permanent restraining order, and then if they weren't transferred, then there could be a warrant and perhaps a seizure and a search. So it's not just the timing. What you're doing is you're eliminating the hearing. So if the seizure if the person does nothing after 24 hours and a search warrant issues, a search warrant will issue without a hearing, and the only probable cause would be that they failed to surrender their firearms. Am I wrong on that?
I think I may be missing something, Representative Dubitsky, because if after a full restraining order has been issued, you have 2 business days to transfer the weapon.
Right.
If you fail to do that, there would be a process, as you described, a warrant, and that. Move that ahead 14 days, that same process is in place. If you fail to transfer that firearm, which is, again, what's required at the end of the 14-day period, at the end of the 24-hour period, the same process attaches.
Right, but the difference is there's no hearing.
You asked me what happened. The process
Right.
does not change. Yes, you are indicating that prior to a full restraining order being issued, there is a hearing. That is correct. But you asked about the process for the transfer of the weapon. That process does not change. It is simply moved ahead 14 days.
Okay. Now, why not just hold the hearing within 24 hours of having the
Because
temporary restraining order issued?
Because some people can't get a lawyer fast enough, and if you're served automatically, this is, we're now talking about the respondent, they have to have time to hire a lawyer, get their case ready. As it is, it's a very fast time for them to get this case ready. But if you want to do it in 24 hours, you're not being very fair to that person that is the respondent.
But that would be...
There-
I'm sorry.
And if I may, Representative Dubitsky, currently there is a process for an ex parte restraining order, which means that this legislature and the courts have felt that there is a reason why there are things that need to be issued immediately because of the potential for harm to a victim. And then before a full restraining order is issued, there is a opportunity for a hearing. There are a number of things currently under law that an ex parte restraining order does to an individual without a hearing. Can deprive them of an opportunity to be in their home, can deprive them of the ability to go anywhere they want to because they need to stay away from the victim. It may deprive them of an opportunity to see their children. And in this particular proposal, it would also require that if they are in possession of a firearm, that they are required to turn that firearm over within 14 days, within 24 hours, excuse me.
Well,
The goal of this legislation is to reduce the risk to victims of domestic violence in a very critical period of time.
taking a defensive firearm away from somebody, whether it be the victim or the perpetrator, is clearly it affects their constitutional rights. Doing it without a hearing certainly affects another set of constitutional rights. So in order to prevent infringing on Second, Fifth, and 14th Amendment rights, could not a hearing take place prior to the seizure of the firearms? It doesn't have to be. It wouldn't have to be a full-blown restraining order, permanent restraining order hearing, but just a hearing on whether or not there is cause to take away the firearms in that instance, and see whose firearms are properly taken. Again, my concern is that under this, it's too easy for the abuser to turn the tables on the abused and have the abused, the defensive firearm of the abused taken from her. And without a hearing, there's no way to know. All the judge sees is an allegation on a piece of paper. So why would we not have a hearing, at least on the seizure of the firearms?
Again, you're talking about due process. There is due process. And there are other states, as we've indicated, which have similar processes, including in some states the seizure of those firearms immediately. There is, you are indicating that there is no due process, and I believe that is inaccurate.
Well, there's no due process before the firearms are seized. Do you agree with that?
No, I do not.
What's the due process?
Again, there is a hearing before the judge. There is a sworn application that is made, and there are those circumstances coupled with before the entry of a full restraining order provide sufficient due process under the law.